Praising Allah subhanahu wa ta'ala and sending salutations upon our Prophet Muhammad sallallahu alaihi wasallam. We express our gratitude to Allah subhanahu wa ta'ala for guiding us and making us in the ummah of Muhammad sallallahu alaihi wasallam. Before beginning, we ask Allah subhanahu wa ta'ala for ease as we all are undergoing this pandemic. Whoever listening is sick, we ask Allah subhanahu wa ta'ala to grant them shifa kamilan. Whichever family members of ours, whichever relative, any acquaintance of ours is undergoing this sickness and bearing the hardship and difficulty, we ask Allah subhanahu wa ta'ala to grant him afiyah, to relieve this person of his suffering and to bring him to his normal condition and even better. And whichever family members of ours have passed away due to it, we ask Allah subhanahu wa ta'ala to grant them the status of a shaheed, a martyrdom, and we ask Allah subhanahu wa ta'ala to forgive all their shortcomings and grant them the highest levels of paradise among the Nabiyyin, Siddiqeen, wa Shuhada, wa Salihin. So inshallah today we will go over some principles governing the Islamic law of inheritance. In our Deen, our Deen is very comprehensive and is all inclusive. Not only are we guided on matters of acts of worship like salah and fasting, but we are also guided in other spheres of our life, all spheres of our life: marriage, the rights of neighbors, personal affairs, familial affairs, communal affairs. And among them, one segment of that whole holistic religion is estate planning and inheritance. The system of inheritance, it reserves a very special place in Islam. So just to begin, we can see the concern of our Prophet ﷺ with respect to this subject, with respect to his ummah implementing the laws of inheritance. So there's a narration reported by Abu Hurairah radiallahu anhu in which he mentions that the Prophet ﷺ once called out to him saying, "O Abu Hurairah, learn the rulings of inheritance and teach it to others, because indeed it is half of knowledge. It will soon be forgotten and will be the first science of knowledge to be taken away from my ummah." We can also see the virtue with respect to this science. It's reported by Jabir ibn Abdullah radiallahu anhu that the Prophet ﷺ mentioned such a great virtue for a person having a will and passing away with it being implemented accordingly. He who dies on his wasiyah dies on a clear path. In other words, a clear path leaving no disputes or unresolved issues for his family and making the distribution of the estate easy, dies on sunnah, piety, fear of Allah subhanahu wa ta'ala as a martyrdom, and he dies forgiven. So there are so many different, this hadith is so comprehensive and mentions and highlights the importance of having a will and doing whatever is in our means to ensure that it gets executed accordingly. So, and on the contrary, there's a warning for a person who violates the laws pertaining to inheritance. So we see that the Prophet ﷺ, he mentioned that a man may do good deeds for 70 years of his life, but if he acts unjustly when he leaves his last testament, then the wickedness of his deed will be sealed upon him, and he will enter the fire. On the contrary, a man acts wickedly for 70 years, but in just his last will and testament, the goodness of his good deed will be sealed upon him, and he will enter paradise. So, when a person is close to passing away, he is close to meeting Allah subhanahu wa ta'ala. And, no matter how a person has spent his life, one thing for sure is that if we have that opportunity towards the end of our lives to make it up for all the wrong and for the sins that we've committed throughout our lives, one easy opportunity is to ensure that when we are passing away, we have a will, and we do whatever is in our capacity to ensure that our estate is distributed according to the pleasure of Allah subhanahu wa ta'ala and His Messenger. There's a verse in the Quran which mentions the laws pertaining to inheritance. And in the end, after that verse, we'll come to that verse later on in our slideshow, inshallah. Later, after that verse, we could see the importance given to it when Allah subhanahu wa ta'ala mentions tilka hududullah. These are the boundaries, these are the injunctions placed by Allah subhanahu wa ta'ala. وَمَن يُطِعِ اللَّهَ وَرَسُولَهُ وَيُدْخِلْهُ جَنَّاتٍ تَجْرِي مِن تَحْتِهَا الْأَنْهَارُ خَالِدِينَ فِيهَا. Whomsoever obeys Allah and His Messenger, Allah subhanahu wa ta'ala will admit him into lush gardens and getaways beneath which rivers flow, and that is a magnificent accomplishment. And on the contrary, one who disobeys Allah subhanahu wa ta'ala and His Messenger and crosses the limits and boundaries, Allah subhanahu wa ta'ala will enter him into the fire, living therein forever, and he will be suffering a painful punishment. May Allah subhanahu wa ta'ala protect us all. So I just wanted to begin our session today just by highlighting some of these points. Number one, the concern of our Prophet ﷺ. Number two, the virtues. And number three, the warning. By this, we can all gauge the significance and importance of this subject. Now, inshallah, let's start getting into the actual the laws pertaining to it and some essential preliminary points. So point number one, taking steps to ensure correct distribution begins before passing away. So again, taking steps to ensure correct distribution begins before passing away. Majority of the times, I'm highlighting this point because majority of the times death occurs unexpectedly, and we can't wait for it to happen and then begin planning. This is such a matter, it's strange. It requires planning beforehand, but what is beforehand is unclear because we don't know when we're going to pass away. Point number two, and inshallah I'm going to elaborate a little bit on these points inshallah afterwards. Number two, instructing the family about what you wish to be done about life support. Now, this is obviously not related directly to the subject, but it is very pertinent and it's very important. When a person is on life support, emotions of family members are already very unstable. Then they're put in a dilemma. If someone suggests, okay, he's suffering enough, let's take him off life support, then others may accuse him like, oh, what's wrong with you? You just want him to die early, and you just want this to, you have no heart, you have no shame. And although the suggester, he is doing this in the best interest of the person who's passing away, maybe he's suffering immensely. And at times, it's just like a very sensitive moment, and this leads to harsh arguments, which can easily be averted by, the person on the bed instructing his family beforehand what he would wish to be done. The next point is burial expenses. Inshallah, we'll go over that in a bit of detail in the upcoming slides. Next, clearing debt and discharging the wasiyah. So ensuring correct distribution during our lifetime. What does that entail? Now, we have to remember that those who are inheriting us is our own family, our own children, many times. So it's a responsibility upon us all to have and express concern for our children, to our children, following Islam. Just as we all parents worry about the success of our children's success in this life, having a good education, a job, marriage, we need to worry also about the success of our children's afterlife. And the importance of this can't be stressed enough. The world is finite, whereas the hereafter is infinite, is forever. Therefore, we need to counsel them to be content with whatever share they are entitled to receive in Sharia. So what is the story of Yaqub alayhi salam that is indicated on the slide? Once Yaqub alayhi salam, being a prophet, he called his children and he asked them that, he was on his deathbed and he was concerned about what they will do after he passes away. Are they going to stay firm on Islam? Are they going to continue worshipping Allah subhanahu wa ta'ala? Are they going to leave? So he asked them very frankly one time. He gathered them and he said, "Ma ta'buduna min ba'di?" What are you all going to worship when I pass away? And then they all responded, قَالُوا نَعْبُدُ إِلَهَكَ وَإِلَهَ آبَائِكَ إِبْرَاهِيمَ وَإِسْمَاعِيلَ وَإِسْحَاقَ. They said that we will worship your Lord and the Lord of Ibrahim, Ishaq, alayhi salatu wasalam, one Lord. And the lesson we draw from this is that, at times we need to have that very open conversation with our family members that, okay, I'm going to pass away and this is what it is. And are you all going to be listening? Are you all going to accept the shares that are going to be distributed? And our scholars also advise that in our will, we should also write guidelines for our family members. Of course, take care of your mother, take care of so and so, my friend who is also in need, and so relative, your uncles and aunts, etc. So it's our responsibility. We need to counsel them about not being too greedy, and we need to counsel our children, our family, about life being short and the afterlife. And how many stories, unfortunately, do we hear of Muslim families, biological brothers and sisters, sons and daughters, shattering their ties with one another over their parents' property, over their relatives' property. And it's really heartbreaking. At times, they won't even attend each other's janazah. Subhanallah, really has greed for wealth made us stoop so low that we are willing to give up even seeing the very people that we grew up with, our own family, and whom we have such a inherent deep relationship with. So we as parents have the power to save our children and our family's relationship by simply counseling them beforehand. And it's not in our it's not enough in our times to merely just tell our children laws and say follow this. We need to teach them to appreciate the laws, to understand the benefits of the laws of Islam, and teach them how to love them. Okay, next point, burial expenses. So in principle, this expense is actually due from the deceased person's wealth. Expenses include the burial cloth, coffin, if needed, maintenance of the body, grave digging fees, plot of land, etc. So again, I'm just trying to mention that in principle, this would be like the default situation. But many times it happens that, community and relatives, they get together and they pay for the above expenses, right? For a family in need, and this is, very rewarding. And may Allah subhanahu wa ta'ala allow us to continue doing this if we have been doing it, and allow us and bless us for it. Some expenses that are not to be paid by the estate, again, in principle, is like functions and events. So if many times it happens that after a person passes away, there are certain events that are held, parties, etc. So these are not types of expenses that should come out from the deceased person's wealth. By party, obviously, I mean gatherings, etc. Even transportation out of state or out of country. Sometimes it happens that family members may want, if someone passed away far away, they want him to be buried close by. So they should not, that expense, again, it should not come out of the deceased person's assets. It should come out from someone living's voluntary assets. Clearing our debts. So let's see here. So I'm just going to put everything up here. Look, the creditor is placed in a very difficult situation for asking his right. So debts to be paid off include debts to people and mahar that wasn't paid during the lifetime. It's extremely important to pay off our debts, and it is so important that, as you see on the screen, that the Prophet ﷺ refused to pay the janazah of a person who had debts. I mean, we can imagine the severity of that. The Prophet ﷺ was the softest person ever. He was the most compassionate person. He forgave the very people that persecuted Muslims and persecuted him for extended periods of time, unbearable torture. But this matter about trying to escape our debts and to not pay them off is so hated, so disliked by the Prophet ﷺ that he refused to pray the janazah of a person. So there's a authentic narration that once a person, he passed away and he left behind just 2 dinars. 2 dinars is not even a significant amount, relatively speaking. So even considering that time, maybe a few $100s at most. And the Prophet ﷺ, he did not pray his janazah until there was one Sahabi by the name of Abu Qatada radiallahu anhu. He came and he vouched and he said, Ya Rasulullah, I'll take care of it. And the next day he came to the Prophet ﷺ and he said that, Ya Rasulullah, I paid it off. And upon hearing that, the Prophet ﷺ told him that now you've put him at ease. Before he was in a state of discomfort and pain, and now by you paying off his debt, you have just relieved him of all that suffering that he was going through. Okay, every individual is in a different circumstance, so talk to a scholar to understand what debts must be paid immediately and what can be paid over time. So, of course, we have these student loans, mortgage, these different types of loans that a person may have, and is it necessary for all? Now, I think there's a very important point here, which is that when a person passes away, before his money even goes to his heirs, the debts have to be cleared. Right? Before the rights of the heirs. Right? Before the rights of the heirs, there's the rights of creditors. So it could even happen that, let's say, a person passed away with only $50,000, and he owed someone $50,000. So that $50,000 will go entirely to the creditor, and the rest of the money, there's no rest of the money, then the heirs will be left out because there's no money remaining. So the rights of the heirs actually come after the debts. So just to, you see these in the essential points, this slide here, these three expenses that we see, let me just take out this laser pointer. The burial expenses, the debts, and discharging the wasiyah, these three come before the distribution of the inheritance. So before the money is handed out to the heirs. So now what do you do when a person passes away and he leaves behind like a huge debt for the home as well? So then that will obviously be a little different, because if a person only left behind $50,000 and they have a $150,000 loan on the house, then it's a different situation. Someone has to take responsibility of the house. I mean, it gets a little complicated, but I want everyone to understand, if there's a personal debt, then meaning a person took a loan from an individual, a family member, friend, then all of that has to be given to him. Okay, then there's discharging the wasiyah. So what is the wasiyah? So let's talk about this. Wasiyah is the right to distribute up to a third of a person's wealth in his or her lifetime, which will go on to be executed upon death. Okay, so wasiyah again is the right to distribute up to a third of a person's wealth in his or her lifetime, which will go on to be executed upon death. Any gift that's given right while a person's healthy is not wasiyah, it's a gift. Okay, next point. 1/3 of your wealth can be distributed to family members ineligible to receive inheritance, charities, mosque, etc. The remainder would pass per the rules of inheritance. So as you see underneath conditions, there's a limit of 1/3. A person who has no debts and after burial expenses, clearing the debts, he has, let's say, $100,000. He can only use 1/3 of that. And where can he use 1/3 of that? He can use it towards family members, but again, family members ineligible to receive inheritance, charities, mosque, waqf, etc. And then the remainder would pass per the rules of inheritance. Wasiyah also includes appointing a guardian for minors, appointing a will executor, and maybe some personal requests from family members. As I mentioned before, instruct the son, please make sure you take care of so-and-so person. Make sure you, whatever advice he wants to give him, education related or salah related. A person should ideally also mention a few points about adhering firmly to Islam, because when they see that this is actually one of my father, one of my mother, my brother, my sister's final request to me, then that may have a profound effect on them. Make dua for me every single day, or every other day, and give charity on behalf of me one time, a week, $10 or $100, whatever it is. So things like that. But here are the conditions for a wasiyah. Number one, 1/3 of the wealth is considered. Okay, so a 1/3 of the wealth is considered after subtracting debts and funeral expenses. Okay, so when we say 1/3, it's not 1/3 of the entire amount a person leaves behind. It's 1/3 of the wealth after subtracting debts and funeral expenses. So just to give an example, okay, if a person left behind $100,000, then 1/3 of that is 33,333. Okay, so they can do whatever they want with 33,333. But if their funeral expenses are not sponsored by other family members, and if they have debts, so sorry, let me say that again. If someone else sponsors their funeral costs and he leaves behind no debts, then yes. If he wanted to give 33,333 to an organization, then the entire 33,333 would go towards that organization. But if this dying person had debts. He had debts of $50,000. And the remaining amount after clearing the debts was $50,000. Then, even though he wrote in his will, give 1/3 of my wealth, 33,333 to such and such organization, that will not go through. That should not go through. The heirs should discuss and talk to the organization and let them know that he only left behind this much and he wrote for you so much. So then there should be ways to work around that. But in principle, the the dying person could have only donated $16,666. Okay. And there's a very important point that I thought I'd mention here too, which is that why in Sharia does a person have a limitation up to 1/3? Right? It's his money, and it's his money. Why is there a limitation up to 1/3? It's because it's a right of the heirs. It's a right of the heirs that a person leaves behind money for them as well. There's a narration, inshallah, I'm going to try to summarize it in a few words, where there's a Sahabi, Sa'ad ibn Abi Waqqas radiallahu anhu, and he was passing away. He wanted to do a lot of good before he passed away. He wanted to give away all of his wealth in charity. And the Prophet ﷺ said, no, you can't give away, leave behind some for your heirs. And he said, okay, should I leave behind this much? Should I leave behind this much? Should I leave behind 2/3? What about half? And then eventually it came to, okay, can I give 1/3 in charity? And the Prophet ﷺ said, yes, 1/3, and that's a lot. And it's better that you leave money for your family members so that they are not dependent upon others. And the Prophet ﷺ even had told him that if you leave behind it for the sake of Allah, if you leave behind wealth for your family, then you will get reward for it. Right? If you leave behind wealth for your family for the sake of Allah subhanahu wa ta'ala, you will even get reward for it. And even in that narration is that even you feeding your wife food with your own hands, right? For the sake of Allah subhanahu wa ta'ala, to keep good relationship, you will be rewarded for that too. So if someone does even a permissible act with a good intention, he gets reward. So anyways, that's a point that I thought to be highlighted, that why is this 1/3 condition there? Another very important point is that since there's a limitation of 1/3 due to the heirs' rights, if the heirs choose to forego their right, then that is permissible, and more than 1/3 can be given. So, if, for example, in the same example, someone wanted to donate $33,333, and he only left behind $50,000 after all the debts, then the family members can say, all right, you know what, since it's being done for a good purpose, it's okay. We don't mind if more than 1/3 is being given in away, and it will be fine. There'll be no problem. Okay, and last point, this is very important. Wasiyah cannot be distributed to an active heir. In other words, can't give extra from the 1/3 to someone already receiving inheritance. Many times people ask, they love one son more than the other son. They love a daughter more than another daughter, or they love a brother more than another brother. Maybe one son was disobedient their entire life. The other one was very fulfilling. So it's not right. It would be wrong to give a person one heir more than the other heir. So just to give an example, if someone leaves behind a son and a grandson, so just explaining this word active heir, the grandson does not receive anything in inheritance. So a dying person, if he has a son and a grandson, he can write in his will that I would like to give to my grandson this much money, $10,000, if it happens to be less than 1/3. But he cannot gift his son an extra dollar, since he's already receiving money from the inheritance. Okay, so this is a slide that kind of highlights briefly some differences between mirath. We may have heard the word mirath, inheritance, and then wasiyah. So wasiyah is the 1/3 distribution per your wishes. Mirath is the other 2/3, which deal with your assets to be distributed per the formulas in the Quran and Hadith. The difference, wasiyah is in the control of a person, whereas mirath is not. Okay, wasiyah is in the control of a person, whereas mirath is not. And the term will can be inclusive of both things. All right, now we're getting into the laws. So the primary basis of mirath, the Quran and Hadith. So there are many factors to be taken into consideration when solving a particular case. I just want to give a heads up. There's only so much we can cover in 45 minutes. Inshallah, we will try to cover some broad principles which relate to everyone and go into specifics of some cases to gain an understanding of some factors which play a role in determining the shares, inshallah. But to be honest, it will take probably days. There's a whole course we do at Dar es Salaam. Alhamdulillah, Allah subhanahu wa ta'ala has given me the ability to teach this subject at Dar es Salaam, and I can tell you that we have a 40-minute period almost every 5 times a week throughout the whole year, mostly throughout the whole year, just to cover this subject in detail. So it's hard to kind of put everything in and summarize everything into, actually it's impossible, into a 40-minute presentation. So we're going to try to understand, inshallah, main principles which will relate to everybody, and some specific principles that could apply to certain individuals. But at the end of the day, I would strongly advise that you talk to an attorney and talk to a scholar and get it sorted out, inshallah. So this is just I just wanted to show from a section of the Quran. It is a very long verse, as you can see. And in this very long verse, there are many rulings pertaining to inheritance mentioned. So if you see the pointer right from the beginning, لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ فَإِنْ كُنَّ نِسَاءً فَوْقَ اثْنَتَيْنِ فَلَهُنَّ ثُلُثَا مَا تَرَكَ وَإِنْ كَانَتْ وَاحِدَةً فَلَهَا النِّصْفُ. My purpose in sharing this with everyone is just for us to understand that, the rulings of inheritance, they're very crystal clear. They're mentioned in the Quran very explicitly, and there are many subjects of law in our in Islam. There's salah, zakah, som, hajj, zakah, nikah, talaq, hajr. There's like 10, so many of them. But what's very special and unique about this subject is that the rulings are explicitly mentioned in the Quran to so much detail that there's very little difference of opinion. In other, in Salah, you may even see some people praying, they raise their hands, some don't raise their hands, some say Amin loudly, some say don't Amin loudly. There's so many differences, right? But when it comes to the subject of inheritance, there is very less difference of opinion because the Quran gives so much space to discuss each scenario. There's only a few scenarios that are not discussed very explicitly. Another point I just wanted to highlight while we're on this slide is the last these 2 sentences here. The first one is that لا تدرون أيهم أقرب لكم نفعا. That we may ask, like, okay, I want to give a son more than the other son, a daughter more than the other daughter. And Allah subhanahu wa ta'ala in this verse is telling us that لا تدرون أيهم أقرب لكم نفعا. That although you may want to give one son more than the other, you don't know which of them will benefit you more in the long run, in the hereafter. Maybe one will end up making tawbah for all the wrong that he did. Maybe he will do so much more to make his parents happy on the day of Qiyamah. And the one who is good, may Allah keep him good, but perhaps he may change. At the end of the day, we don't know who will benefit us most. So that's why we are commanded to treat our, just follow the laws that are given, that are told to us, and give each child equally. And the second sentence I want to highlight is that which is circled with the green marker, that Inna Allah kana aliman hakima. that indeed Allah subhanahu wa ta'ala is all-knowing and all-wise. Um, we may be going through certain laws, and we may be wondering, why is this like that and why is that like that? And these are inquisitive thoughts that may naturally appear to our mind, but we need to always remember and counter those thoughts if they lead towards negative thinking, that at the end of the day, this is Allah subhanahu wa ta'ala who is giving me this law, and He is more knowing. He is all knowing and He's all wise. If we compare ourselves to, like, if we think about the example of a parent and a baby, my 2-year-old son every day without fail puts himself in danger without doing something, by doing something very risky. And I'm sure we all have experiences like this. So we all as parents, prevent our children from such reckless acts because we foresee something that they don't, due to our intelligence and understanding. In the same way, no matter how intelligent and understanding we may be, Allah subhanahu wa ta'ala is more intelligent, more knowing, and more wise. And being a Muslim dictates that we leave this, we surrender our intelligence to the all-knowing and to the all-wise. There are going to be some commandments where the harms of which we can clearly see. For example, drinking. In the United States alone, there's been studies done that nearly 300 people die from drinking every single day. But Allah subhanahu wa ta'ala, He has forbidden us He forbade us from that. So there are some prohibitions that we see, like, okay, this is the wisdom behind it, and some that we may not see. Just like, why do we pray 5 times a day? Why do we give 2.5% of our money in zakat? Why is there Hajj only one time? There's questions that we could ask, but at the end of the day, we shouldn't object. We should just surrender to Allah subhanahu wa ta'ala as well. Okay. Now here are some fundamentals. Now we're going really deep into the meat of the discussion. So the first point: distributions generally go to relations by marriage and blood. Marriage and blood. So what's excluded from here? Adoption. Again, we're talking about inheritance, right? Inheritance, if someone adopts a child, then the adopted child does not get anything from the inheritance. He could be given from a will, but he's not going to fall under the category of heirs. So if there's no marriage or blood relation, like stepchildren, adopted children, then they will not receive anything in inheritance. Okay. Next point. Reasons that block distributions to certain heirs are, for example, killing the deceased, difference of religion. So, it's even happened in the past that, some people, out of greed to hurry and get their share from their family member, they may do something which, na'udhu billah, even lead to the murder of a person, just so that they can quickly inherit whatever money that they leave behind. Islamically, if a person does something like that, then forget about inheritance. He's not going to be entitled to anything. That's just probably the most minor punishment that he's going to get. And of course, there are much graver sins for that. In the Quran, Allah subhanahu wa ta'ala says, the one who kills a believer intentionally, فَجَزَاؤُهُ جَهَنَّمُ خَالِدًا فِيهَا وَغَضِبَ اللَّهُ عَلَيْهِ وَلَعَنَهُ وَأَعَدَّ لَهُ عَذَابًا عَظِيمًا. That someone who does such a thing, then Allah subhanahu wa ta'ala will punish him forever, and His wrath will be on him forever, and He will curse him, and He has prepared a very painful punishment for him. So the killing the deceased, difference of religion. So being of a different religion disqualifies a person from being an heir. Next point. Active heirs are not disinherited if widow remarries, children are disobedient, infant minors. So these are some misconceptions that people have. Let's say that a male passes away and his wife remarries. And then for some reason, let's say that the inheritance was not distributed as of yet. So the family members cannot deprive the widow from the inheritance and say that no, now you're married and you won't get anything from the inheritance. That's wrong. If children are disobedient, and remember the verse that we just discussed not so long ago, and then infant and minors. If they're infant and minors, they still get a share of the inheritance. Their account has to be kept separate. About how much do they get of the inheritance, and it's not like whatever money they get. The other parent can just take it away, or the siblings can just take it away. That's not right. Okay, possible heirs. So here's just like a very big list. I'm gonna try to go through this very quickly. These are just possible heirs: a daughter, mother, ascendants, grandmothers, etc., wife, son's daughter, maternal grandmother, paternal grandmother, full sister, sister, same father, sister, same mother. Among the males, sons, father, then father's father, husband, full brother, half brother, full brother's son, nephew from father's side. This is just a list of people that, in principle, could be entitled, but as we will see in the next slide, generally most of the relatives listed do not inherit at all. And why? That's because some heirs have a preferential right over others. Like if there is a son, then the grandson does not get. If there's a father, then the grandfather doesn't get. So that was on the previous slide. There's just a list of people who, in principle, are eligible, but they may not be if depending on the situation. And another point to keep in mind is that not all relatives inherit same amount. Some get more than others. And in short, the amount and who inherit depends on who survives. Okay, so now here's an example, a very simple example for us. So a person passes away and leaves behind a son and a daughter. So the son would get 2/3, whereas the daughter gets 1/3. So, if father passed away or mother passed away, son would get 2/3 and daughter gets 1/3. Again, this distribution is in clear words of the Quran. One may wonder why, what's the wisdom behind the male getting 2 times, in some cases, by the way, in some cases getting twice the amount of the female. And as Muslims, we say that what's the actual reasoning, what's the true wisdom behind it, only Allah Ta'ala knows best. But just for some kind of understanding, if we look at just this law, then perhaps this question may seem like, okay, son gets 2/3, daughter gets 1/3. That outwardly does not seem to be fair. But we have to remember that the rulings of Sharia, they complement one another. So, in Islam, the financial responsibilities in marriage and even outside of marriage fall on the shoulders of the male. The male is responsible for taking care of the parents. Again, in principle, taking care of his siblings, sisters, taking care of his wife. In principle, right? If both husband and wife are working, etc., that's a different situation. And the responsibility, though, in principle, is still upon the husband. So even if the wife is a doctor and the husband is barely making money, he's I don't want to be specific, but actually I'm not even going to give an example, right? Just not in case, not to offend someone, but if he's doing something that's earning only $20,000, $30,000 a year, even then it's his responsibility to take care of her, right? It's his responsibility to take care of her. And she should, of course, be open with him about how she spends, so that there's love and continuity in the marriage. But again, in principle, the financial responsibilities are on the male, not just in marriage, but as I was saying, outside of marriage, towards the parents. So perhaps that could be a reason why the male gets more than the female in some cases. But we have to remember just that the ultimate wisdom, Allah knows best. And one thing we can gauge though is that we see that in Sharia, the male has more financial responsibilities than the female. Okay, next scenario. So let's look at this one here. There's a daughter and granddaughter. So as you can see, the son is crossed out here. So a person passes away, leaves behind a daughter and a granddaughter. And let's just assume that the son has passed away. Son passed away before the deceased. Okay, so the daughter gets 3/4 and the granddaughter gets 1/4. Okay, so let's see here. There's daughter. Oops, sorry. Next is let's say there's a daughter, a grandson, and granddaughter. So someone passes away, leaves behind as heirs only the following. He leaves behind two daughters, and he had a son too, but the son passed away, and the son left behind another son and another daughter. So to the deceased, these are two daughters and two grandchildren, a grandson and a granddaughter. So in this type of case, the two daughters will share 6/9 of a share, so they'll each get 3/9, right? Then the grandson will get 2/9, and the granddaughter will get 1/9. So let's look at the next here. Okay, here's husband-wife scenario. So if the wife passes away and she leaves behind, for example, two daughters, and her and her husband leave behind two daughters, and the husband is the only other heir besides the daughters, then the husband would get 1/4 and the daughters would share 3/4. Husband 1/4 and the daughters they share 3/4. Now, if there was no children alive, so if there were no children alive and the wife passed away, okay, the wife passed away, then the father gets half and the husband gets half. So when there are children, when the wife leaves behind children, the husband only gets 1/4, and when there are no children, the husband gets half, father gets half. Okay. Now let's look at it the other way around. What if the husband was the one who passed away? So this is the wife's share now. So if the husband passed away and left behind a father and a wife, then the wife would get 1/4 of the estate and the father would get 3/4. In this same case, when it was the other way around, wife passed away, leave behind father and husband, the husband got half, father got half. Over here, the father gets 3/4, the wife gets 1/4. And again, these are all explicitly mentioned in in a verse in the Quran. And then in another scenario, when the husband passes away, leaves behind a wife and two daughters, then the two daughters would get 7/8 and the wife would get 1/8. Another point I just wanted to mention, very important, right? And I think, sorry, I should have been mentioning this throughout the slides, is that these only kick in, these laws only kick in when a person passes away. So if someone feels that their wife needs more support than just 1/8 when they pass away, then they can gift them whatever they want, however much money they want. They can gift it to them while they're alive. What we strongly advise, what I strongly advise is that a person has a frank conversation with one's spouse about ownership. So as we all know, in the United States of America, there's joint ownership of a lot of things like house, bank accounts, and when one person passes away, the other becomes 100% owner. There's no precedence for this type of ownership in Islam. How can two people be 100% owner of a property? It just doesn't, logically, it just doesn't kind of make sense. Because look, if we say that let's say there's a bank account, there's a house. No, let me use bank account. It's easier. Bank account, $10,000 in the bank account. If husband is 100% ownership and wife is 100% ownership, when the husband passes away, if he was 100% ownership, if he was 100% owner, if he was 100% owner, then that means that there has to be a portion of it that goes to the heirs. There has to be a portion of it that goes to his heirs. Because if he's 100% owner, and we know Islamically that there's a system of distribution of a person's ownership, then the heirs have to be a part owner of what he left behind. And if we say that he's not the owner, and it's only the wife that's the owner, then then that just means that it was never his money from the beginning. So again, it's just hard to kind of, what if both husband and wife were to pass away and they're both 100% owners? Okay, this creates a lot of complications. If husband and wife, they're both 100% owners of the bank, of the money in the bank account, and they both were to simultaneously pass away, then how will the money be distributed then? Will we look at the husband or the wife? This creates a lot of confusion and problems. That's why the best way around this is that a person should have a frank conversation with his spouse or her spouse and say that, okay, in the bank account is 50-50. So if anything ever happens, then we'll assume automatically that you're 50% owner, and therefore the distribution of your inheritance would take place accordingly. And I'm 50% owner, and if I were to pass away, then this is what would happen. And it's not the easiest conversation to have, but we for the sake of Allah subhanahu wa ta'ala, we need to prepare to meet him in a way that he's pleased with us. Man ahabba liqa Allah, ahabba Allahu liqa'ahu. The one who loves to meet Allah subhanahu wa ta'ala, Allah subhanahu wa ta'ala loves to meet him as well. So these decisions can play a very important role, as stressed in the beginning of this slideshow, about how our condition would be after we pass away. So may Allah subhanahu wa ta'ala give us all the tawfiq. Okay, so it's 2:52. I'm going to inshallah just quickly summarize, just go over these last few slides, and if there's any Q&A, we'll answer them inshallah. So this is just an example of one person's share. In total, a mother may receive the following amounts considering those alive. So she could be receiving 1/6 if the deceased is survived by the following people: any children, 2 or more siblings, whether full or half. Only parents and a husband are survivors, considering the deceased is a female. And number 2, 1/3, that's in the absence of the above 3 scenarios. And number 3, 1/4, this is when only parents and wife are surviving, right? And this is considering the deceased is a male. Here are some very important general principles pertaining to this subject. Okay, so let's look at this. Number 1, when a person dies, those relatives who are alive at that distinct second become the heirs. So consideration is given to when a person dies, not when his inheritance is distributed. Some of these points may sound repetitive, but I've just chosen to mention them separately so that the image is clear. So look, when a person dies, those relatives who are alive at that distinct second become the heirs. Not later on when a person, his money is being distributed, you look at who's alive. Number 2, not distributing the estate will not prevent ownership of the entitled heirs. In simple words, if, many times like in India, Pakistan, and Bangladesh, or in other countries, when someone passes away with land, there's usually it takes a long time to have the documents ready, right? For selling and proof of ownership. And in those cases, let's say years pass by, then and then the land is finally able to is released for distribution, then who will be the deserving ones? So we will always look at a person. Uh, we'll always look at those who were alive when the first person was alive, and if there was anyone else that passed away, then we look at them and their heirs. So inshallah, we'll do an example quickly. Number 3, if an entitled heir does not receive his share and dies, then that share will be counted amongst his personal estate, and now his heirs will be entitled to that undistributed share. So let's look at an example. Zainab's assets. Zainab passes away and is survived by her husband Zayd and mother Maryam. Just simple example. Zainab passes away and survived by her husband Zayd and mother Maryam. Due to certain issues, Zainab's assets could not be distributed right away. Okay? Then 1 year later, Zayd dies before receiving his share from the estate of Zainab and leaves behind his father Abdullah and mother Aliza. So then, so who's alive? We'll see. Finally, Zainab's assets get released and now can be distributed. So as of now, right, there's only 3 people. Zainab's mother, Zayd's mother, and Zayd's father are alive. And Zayd's parents are not heirs of Zainab. So since Zayd's parents are not heirs of Zainab, they wouldn't be entitled to inheritance from the beginning. But you see, when Zainab passed away, her husband was alive. So her husband, right away, he becomes owner of her assets, half of her assets. Then 1 year later, when Zayd dies, then that asset from Zainab gets transferred on to his heirs, right? His mother and father. So that's why it was stressed upon in the last slide that if an entitled heir does not receive his share and dies, then that share will be counted among his personal estate, and now his heirs will be entitled to that undistributed share. So I hope that inshallah is clear. Number 4, an heir cannot prevent himself from being an heir. What does that mean is that since the law of inheritance is something that Allah subhanahu wa ta'ala has decided, there's no say of a person in it. If a person, let's say he, may Allah forbid, hates his brother so much that he says, I don't even want to look at his property, I don't even consider myself as an heir of his, then that's wrong, right? No matter what, he's going to be an heir of his. He cannot prevent himself from being an heir. And it's such a strong level of ownership transfer that it doesn't even require taking possession. So Islamically, there are some contracts which require possession taking, even in the legal system, like a gift. If you tell somebody that I'll gift you $100, but then for some reason you're not able to gift him that money, then you're not legally bound to give him that money. And Islamically as well, if there was some reason for which you had to change your mind, then he cannot forcefully get it out of you by going to the Mufti Sahib. So, but inheritance is such a thing that it doesn't even require taking possession. And number 6, one cannot merely give up his personal property, but one cannot give up his personal property by merely saying so. What this means is that a person can look. If I have a phone, if I own a phone, and I say, "Oh, I don't like my phone. I don't own my phone, or it's not mine," then I'm still the owner of the phone. I can't just disown ownership in that manner. If I say, for example, that I'll give my phone to my friend, my relative, and then they take possession of it, then you can say that they took it and they kept it, and now the ownership transferred. So in the same way, the reason why I'm mentioning this point is that at times, like mentioned before, some people, may Allah forbid, have so much enmity towards a person, family member, and they say like, "Oh, I'm not even touching his money." But so it's necessary for him to at least identify where he would want the money to go. I want the money to be given to charity, or you all keep it, right? But if he says, I don't want it, and then a year later he changes his mind and says, oh, I actually want it now, then he will still have the right to take it back, unless he already mentioned where he wants the money to go and he transfers the ownership by doing that. Okay, last thing, that everything that the deceased leaves behind is owned by the heirs in proportion to their share. If someone dies and leaves behind 3 sons and 3 cars, each son has equal percentage ownership in each car. The bigger brother cannot just say, oh, I want a better car, and the middle brother, I mean, they can reach an agreement afterwards, but in principle, everything that a person leaves behind is owned in proportion to their shares. So the house, the car, the clothes, even the clothes, the furniture, the sofa, the table, the food, everything that a person leaves behind. And they'll have to talk among themselves if they want to reach like a mutual agreement so that they could practically distribute it. Okay, and violating rights of heirs. Cutting out heirs or giving less than the required fixed share. You cannot give less than the required share. Un-Islamic conditions. You must marry in order to get inheritance. You must go to medical school to get your inheritance. This is not Islamically correct, right? This would be wrong. Okay, number 3, picking and choosing assets, right? Heirs have a right to own their share in all your assets, not just some of your assets. Okay. Giving a wasiyah in excess of 1/3. Okay, here's the conclusion. This is my last slide, and that's it. Laws of inheritance can be tricky and complex. Before you pass away, prepare a will or trust and offer family good counsel. Trusting and submitting to Allah subhanahu wa ta'ala's infinite wisdom instead of objecting. You can distribute assets during your lifetime in any manner you'd like without worrying about mirath distributions. Finding ways to fulfill our spouse and family's needs whilst complying with Allah subhanahu wa ta'ala's orders by consulting scholars and lawyers, and ultimate success meeting Allah subhanahu wa ta'ala and messenger in a state of in which they are pleased. So inshallah, with that I'll conclude. Subhanallah bihamdi, subhanakallah bihamdika, ashhadu an la ilaha illa anta.
Assalamu alaikum. This is Usman Chaudhary. I want to say Jazakallah khair to Mawlana Salman for presenting regarding the Islamic portion of inheritance. Before we begin, you can go to this website, majiddias.org/lectures, and you can download the slides that I will be using today. It's under the Wills Seminar Slides tab. So you'll be able to, if you click this, you'll be able to download these slides. So I'm going to talk about the inheritance law in the United States. Inshallah, I won't take too much of your time, so we'll just get right into it. Again, go to majiddias.org/lectures to download the slides. If you have any questions during the presentation, you can text the phone number 630-360-2373, and I'll try to address them while we're on the program. Disclaimer, nothing in this presentation constitutes legal advice. It's only for informational and educational purposes. If you have any questions, please contact an Islamic scholar and an attorney to obtain advice with respect to your situation. As Mawlana Salman had said many times, everyone's situation is different. So it's important that you seek the advice of those who are knowledgeable regarding the area. So I want to start off with 4 documents that everyone should have. Everyone needs to have. The first is a living will healthcare proxy. This document, it will cover your healthcare decisions. If you are in a coma, if you are unable to speak, if you're unable to communicate your healthcare decisions, this document, you will be able to appoint a person to make your healthcare decisions on your behalf. All these documents are important because it'll help you avoid going to court in some cases. It'll help avoid disputes between family members. It'll just make the process go smoother and quicker if you have these documents. So the second document that everyone should have, which is going to be the main focus of the presentation, is a last will and testament. This document, it takes in effect when you pass away, and it determines the distribution of your property. We'll talk about what kind of provisions you should have in the document and how you can follow Islamic law in your last will and testament. The third thing everyone should have is a set of funeral instructions. Sometimes people recommend to put it in the last will and testament, but it's better if you have a separate document with your funeral instructions. So, you can write in there that you don't want to be cremated, that you don't want an autopsy, that you don't want to be embalmed. You can write down in there pretty much anything regarding how you should be buried, where you should be buried. And this is really important for everyone because a lot of times what happens is the family members have different ideas of how they want their deceased relative to be buried. So they do things that might not be in accordance with Islam, and they might not be in accordance with the wishes of the deceased. The last document you should consider having is a power of attorney. And the power of attorney determines gives you the ability to appoint an agent to take care of your assets while you are alive. So once you pass away, this document has no effect, and the will comes into effect. But while you are living, you can appoint an agent, say your brother or your adult son, your wife, to take care of your financial, legal matters in case you are incapacitated, in case you can't. You're unconscious, you're in a coma, you're incapacitated in some other fashion. And with all these documents, the most important thing that you should understand is that you have to talk to your family about them. You cannot just have them, go to an attorney and draft them and sign them. It's really important that you talk to your family and they understand why you are doing what you are doing, so that there is no dispute later on. So, in an instance where you appoint one family member to be your healthcare proxy, the others don't fight over it. Same thing with the funeral instructions. So the family honors the instructions, and the last will and testament, so they honor your instructions. The keys for us in living in the United States is that it is possible to follow Islamic law. But there's something that you have to do. You have to act. If you do nothing, then the default rules of the state law apply, and those are not in accordance with Islamic law, which we'll discuss in a few minutes. Just some reasons why you need a will. Some of you might think you don't have any property to distribute, so you don't need a will, but there are other reasons. The main reason is that you have to have a will in order for your estate to be distributed according to Islamic law. Like Mawlana Salman said, this is mandatory. It's a fard act of the distribution to the heirs, and in everyone's case, this is going to actually be their last act. So we shouldn't do something that will violate someone's rights. By not having a will written in accordance with Islamic law, we are essentially violating the rights of the heirs. The second reason we should have a will is so you can appoint a guardian for your minor children. You might think that your brother or sister will take care of your minor children if you pass away, but a lot of things can happen. One is that there might be no one to take care of your minor children. Family members might be fighting to take care of them. One might want it, the other. There might be two sets of family members who want them, and you really need to appoint someone that you can trust. If you don't appoint someone, then it's up to the court to find someone, and they will appoint someone. And in some cases, the minor children end up in foster homes when there's nobody there to take care of the children. The next reason, it's helpful because you're able to get your affairs into order. When you sit down to write a will, you think about all the debts you owe. Sometimes we have debts that we owe to our siblings or our family members that aren't written out, and no one knows about them, and they only come to light when we pass away. And then one family member goes to the other family, the surviving spouse, and they say, "Oh, so and so owed me money," and then there's no record of it. So sometimes that doesn't get paid. It's also useful because you can figure out what assets that you have. A lot of times people forget about an asset, a stock they bought a couple of years ago, or some other small bank account that they might have. They forget about it, but if you really go through your papers and stuff, it makes it easier, and you find out you might have some other assets that you forgot about. And the most important thing with a will is don't wait. Everyone should try to get this done as soon as possible. Usually what happens, during Hajj time or when someone's going for surgery, they go to an attorney and they ask, can you please make my will? That's when most people think about it mostly. But as Mawlana Salman says, we never know when our time will come to pass away, so we should have the will ready as soon as possible. So let's talk about state law. Under state law, we have complete discretion to distribute or pass our property on to whoever we want. So for our purposes, that means we can follow Islamic law. We can follow the distribution to the heirs according to the Quran and Sunnah. And we've seen a lot of people leave their entire estate to either their pets. They'll leave their entire estate to their charities because they want to disinherit their family. So state law really gives you complete discretion to distribute your wealth to whoever you want. Let's talk about what happens if you die without a will. The main thing is that you will lose control. You lose control of how your estate is going to be distributed. First, it's not going to be distributed according to Islamic law. The default rules of the state law or intestate succession will apply. Another thing is you lose control to appoint an executor of your estate. The position of an executor is very important because he is going to be managing your estate. He's going to be paying the debts. He's going to be collecting the assets. He's going to be eventually distributing it to the family members who survive. So it's really important to appoint someone who is trustworthy so they don't potentially run off with the money or something happens to the money. Another thing, you lose control of who will be the guardian for your minor children. We already discussed this. It's really important to appoint someone who you trust, someone who you know will take care of your children. You also lose the ability to make charitable gifts, and it is also more costly if you die without a will. There's a lot of court fees. A bond has to be appointed. A bond has to be posted for the administrator. And all of these fees will come out of the share of your heirs. So they will get a smaller share. What is state law? Generally, across the United States, the state law of distribution is very similar. If there is only a spouse who survives, the spouse will get 100%. If a spouse and children survive, the spouse gets about 50%, and the children divide the remaining 50%. And if there is no spouse, only children survive, the children will receive 100%. So, as Mawlana Salman alluded to, this does not follow Islamic law because in most cases, the parents of the decedent will also receive a share of the estate, the mother and the father. Under state law, there's under these scenarios where there's a spouse or a spouse and children, the parents do not receive any portion of it. Additionally, we have a situation where the sons will get twice as much as the daughters. That will not happen under state law. Children will divide the inheritance equally in the boys and the girls. So the most important thing to know is state law is not in line with Islamic law. And some people might say, if there is no will, we can just redistribute the shares. A lot of times that is not possible because the heirs cannot be forced to consent to the redistribution. Some heirs might be minors, so the court is going to be managing what happens to their share, and the court will not allow the shares to be redistributed. And it might be difficult to divide assets. The easiest way to ensure that your will be distributed according to Islamic law is to write a will. And we'll discuss now how you can write a will. What are the provisions that you need to include in your will? So a lot of times people have different provisions. There's a lot of models out there online. There's a lot of people think that if they put this provision, my estate will be distributed as Mufti Blank says. They're covered. Or they say that my executors will distribute my wealth according to Sharia law. That's sufficient. Both of these provisions will not be sufficient because the court and the state, they want you to tell them how to distribute the estate. They don't want you to say there's so and so third party will tell you when the time comes. Or they don't want to say my estate will be distributed according to Islamic law or the Sharia because of the separation of church and state. They are not going to look into the books of fiqh. They're not going to look into the Quran and Hadith. They're not going to call an Islamic scholar to court to ask them how is this person's estate to be distributed. Sometimes you see will that is 30 pages long. It has every single scenario possible for a distribution, every single heir who can receive your inheritance. Mawlana Salman had posted a slide of all the different heirs who can potentially receive in different scenarios. So there's a 30-page schedule attached with every single scenario. So it includes your brother, your sister, your cousin, your great-grandfather, your great-grandson, your first cousin, your second cousin. And this is very complicated and confusing for anyone who's reading it. So that's usually not recommended either. Another way people do it is they say, I give everything to my son or my daughter or my father, and they will distribute it according to Islamic law or the Sharia. So this provision, if you include it, will be valid to the extent that it is giving everything to your son. Everything after that, the court will not enforce. So the court will enforce it going all to your son, but it cannot enforce the son distributing the inheritance according to the Sharia law. So what you're essentially doing is giving your entire estate to your son, and if he feels like it, he can distribute it according to Islamic law. The best method to use, which is recommended, is to specify the heirs and specify the shares inside of your will. So what you would do is if an individual is survived by his wife, 2 sons, a daughter, a father, and mother, you would write, I give 1/8 of my estate to my wife, I give 1/6 of my estate to my mother, I give 1/6 of my estate to my father, I give 13 out of 120 shares to my daughter, and 26 out of 120 shares to each of my sons. So that's the ideal way to do it, and you would need to get these shares from, ask an Islamic scholar who is versed in inheritance law. They can give you the shares of how your estate should be distributed and what should be listed in your will. There's a few things people always ask, how should a will be drafted? They ask, should we do it ourselves? Should we use online form? Should we go to an attorney? So there's a few things that we should do. Is one, gather all the information about your assets, your family members, and your debts. Like I said before, it's important to have all of your debts and assets known and listed out so that there are no issues after you pass away. People don't come out of the woodwork and say, hey, this person owed me $100,000, I want it now. Second thing is decide if you want to leave a wasiyah. As Mawlana Salman alluded to, a wasiyah includes donating it to charities, donating it to non-heirs, but it also includes leaving advice for your heirs. So if you want to leave them any advice to your sons and daughters, if you want to leave them advice of why you are distributing your wealth like you are, ideally that should be done before you pass away, but you could also include it in the will. After that, you should discuss with your family your estate plan, so everyone is on the same page. And then you can draft the will. Like I said, there are a lot of online templates that you can use. There's a lot of online services now that you can use that will create your will for free. And you can always go to an attorney. The attorney is usually the best person to get your will done because of, you can personalize your will. If you have businesses, the will can address those businesses. A lot of times we have particular family situations, like we have a child with special needs, and you want to address that by creating a special needs trust in your will to avoid losing any state benefits that the child is getting. And the attorney can explain the entire process to you, and he can ensure that your will is properly executed. A lot of times we have we see that wills are not properly executed, and if they are not properly executed, then the court will declare that that will is invalid, and now the state intestate law applies, meaning that the state default rules, and your estate is not going to be distributed according to Islamic law. So I saw one situation where an individual did not execute his will properly. He was in the hospital and he had a will done real quick, by himself, by his brother or sister. They helped him do it, and they had some individuals, some doctors and nurses, witness the will, and the will was not executed properly. We'll talk about how a will needs to be executed properly. So in his will, he had wrote that his father and mother would get 1/6 of his estate. His wife would get a portion. It was according to Islamic law. And the children would get a portion of the estate too. What happens is the will is declared invalid, and then the wife, under state law, she gets 50%, and the kids get 50%, and the father and the mother, they get nothing. In this case, the father and the mother are really upset because what they were planning on doing with their share, which was a significant share, it was close to $1 million for the father and $1 million for the mother, because they wanted to use that money to donate to charities. They wanted to donate some money to Afghanistan to build some masjids. They wanted to donate some money to local masjids. But they were not able to do that because everything was eventually given to the wife and the kids, and they were not willing to redistribute the shares. So I'm going to show a sample will. A lot of people haven't ever seen a will, maybe, or they don't know what it looks like. So this is a sample will. There's different articles in it. Usually you put your name here and where you live. Then Article 1 discusses funeral expenses. Under state law, the order of distribution is as follows. First, all funeral expenses must be paid. Second, all debts must be paid. And then they will look to your will. If there's anything left, then they will start making the distributions according to your will. One thing that you can include in your will are bequests. You can make these bequests up to 1/3 of your estate under Islamic inheritance law to individuals who are not your heirs. You can make it to charities, and this is a really important provision that we can everyone should include in their will. as a distribution to a charity. Just briefly, this is the provision that says, discusses the bequest to a charity. Essentially, it says, I give and bequeath X amount of my net estate passing under this will to, and then you put the charity's name, XYZ charity, and you could put their EIN tax number there too. So the bequests under a will or a living trust are really important because, one, it only takes effect upon your death. So you're not really losing anything while you're living. It's only going to take into effect when you pass away, and that's when the charity will get the money. So during your lifetime, if you spend all that money and there's nothing left in your estate, then the charity will unfortunately get nothing. But you still have control over the money while you're alive. But if you just put this provision in, it's really going to be beneficial for you because you'll get the reward of the charity getting the money. And if a lot of times people think that I'll just leave it all to my children and my heirs, and inshallah they will give it to the charity. But really, in reality, that doesn't happen in most cases because the heirs, whenever people come into some money, they're reluctant to give it. So it's better if you yourself make that distribution, make that provision in your will to distribute a portion of your wealth. It could be a couple of $1,000s, it could be up to 1/3 of your estate to a charity. That will inshallah really help you. It'll be sadaqah jariyah for you. Just to put this in perspective, in 2018, $40 billion were donated to charities through bequests. So this includes all different charities. These are mostly charities, not Islamic organizations. The bequests to Islamic organizations, unfortunately, are very low because not many people put these provisions in their will. So a simple language that you could use is I give, devise, and bequeath to Dar Islam for its general purposes 1/3 of the rest, residual, and remainder of my estate. You could find some of the sample language on our website at masjidds.org/donate/planned giving. There's also other useful information there regarding charitable trusts, which will provide you with tax benefits, immediate tax benefits, and that you can also utilize to help charities and yourself too. Going back to the will, I just want to show you some provisions that you can include, or how it would look in your will with the provisions of the distribution to your heirs. You would have a provision, for example, for the mother. You'd include, if my mother, her name survives me, then she shall receive. And if you draft it yourself, you could include all the possible scenarios that she can inherit under, either receive 1/6 or 1/3 of the balance of the residuary estate, or 1/3 of the residuary estate. Or if you see an attorney, they can clean this up for you and just pick the one situation that applies to you currently and put that in your will, so your will isn't so long. And again, there's other provisions. Article E over here discusses how the estate would be distributed according if you are survived by daughters and sons or no daughters. So it can get a little complicated. That's why it's good to see an attorney, or at least consult with an Islamic scholar regarding the distribution provisions. Last thing in the will I want to show you is it's a really important provision, is a article for appointing a guardian. So normally under law, the surviving spouse will be the guardian, but say both spouses pass away, either together in a common accident or one after another, there needs to be another party who's appointed as guardian for the minor children. In this provision, you would name that person, and then you could also incorporate some requirements saying that the guardian shall educate and nurture your child in an Islamic environment, and make provision to protect the minor child's assets under the will. You can also do that. And the last portion of this will, this is where we see the due execution part. This is where the testator signs and the witnesses sign and put their address. I just wanted to show you this is because in most states, this is all that is required, is that the testator signs and the witnesses sign. A lot of times people think that the will needs to be notarized, or if the will is notarized, then the will be valid. But notarization of the will is not required, and it will not make the will valid or invalid. There are some requirements that you need to meet in order to make a will. One is you have to be 18 years or older. The second thing is you have to have sound mind and memory. Third thing is you have to have testamentary capacity. So these two things, sound mind and memory and testamentary capacity, are really important reasons why you should make a will as soon as possible. If you get too old and you have dementia or Alzheimer's or some mental incapacity, then you cannot make a will, and your will not be valid. It will be grounds for declaring the will invalid. And the last thing is requirements for a valid will is due execution. We'll talk a little bit about due execution. One, it has to be in writing. The testator has to sign at the end. The testator has to sign in the presence of two witnesses. These have to be disinterested witnesses. So it can't be anyone who is receiving under your will. So if your wife is receiving a share, or your father or mother, son, they're receiving shares under your will, they cannot be witnesses to the will. You have to declare to the witnesses that this is your will, and then the witnesses have to sign after you request them to sign. A lot of people get tripped up on the due execution part, and that is why their will is invalid. And make sure you follow your state's laws regarding execution. Recently, due to the COVID-19 crisis, they have relaxed the rules regarding execution. They allow video signings now, so you could look into that also. A lot of times people ask about revocable living trusts. These are an alternative to wills. There's a lot of benefits of this. But one thing you should know is that this does not remove the assets from your possession. You still own them just as if you own them outside of the trust. It's really as if you're moving your money, your bank account from your left pocket to your right pocket. So there's no, you don't lose access to them. You can still use them to pay your bills. You can still use them to make gifts to your family members. The benefit of this is that you do not have to go to court to have your estate distributed. Normally, when you have a will, you have to go to probate court or surrogate's court, and go in front of a judge. The judge has to, you have to submit a petition to the judge with the will, and then the judge, he approves everything and says, okay, this can be distributed like this. People can come and contest it. And it gets costly. But with the revocable living trust, you avoid that whole process. Everything is done by the trustee that you have appointed in your trust document, which is normally you are the trustee in the trust while you're alive. After you pass away, it could be your spouse or a family member. They are the trustee, and they will distribute your estate according to the provisions of the trust, which inshallah should be in accordance with Islamic law. Mawlana Salman talked about a few assets that I also want to touch upon. So the will only controls testate assets or your probate estate. So that includes property you own individually in your name, your car or bank accounts that you own individually. So this does not include non-probate estate. The will is not going to affect these assets. So that is joint property. Husband and wife own a house together, or husband and wife own bank accounts together. Mawlana Salman talked about this, so I won't spend too much time. It also does not include IRAs, 401ks, pension plans, annuities. These will not be controlled by your will. You should put beneficiaries on these plans so that they are distributed to the beneficiaries. which can be, you can put the beneficiaries in accordance with Islamic law, the shares that they should receive. And there's other considerations with IRAs and 401ks when it's beneficial to sometimes leave these to charities because of the income tax considerations. So you can also take that into consideration. So that's, I don't want to take too much more of everyone's time. Just a few more slides. One is about just about gifting in general. A lot of people don't know about corporate matching gifts. This is a lifetime gift that people can make, employees make, and then their company matches their gifts. This is an easy way to double your donation. A lot of companies match the gift, so you can look for more information regarding this on our website, majidds.org /donate/outright-gifts for more information on that. And I'm going to just take a few questions now. There's some people who have been texting some questions. So one question is about a guardian for a minor. The question is, can we assign a guardian who lives in India even though we live here in New Jersey? So it's very difficult to appoint guardians that live abroad outside of the United States. Each state has a vested interest in the child's well-being. So generally, it will be difficult to have a guardian who is appointed outside of the United States as the guardian for the minor. It's also difficult to have, in some states, to have non-resident aliens or resident aliens as guardians of minor children, because the court is going to need to keep tabs on these children, make sure that they are being taken care of, and have jurisdiction over the people who you appoint as guardian. So it's going to be difficult to appoint someone who is outside of the United States as a guardian. Another question is, you said for a will to be valid, notarization is not required. So most states do not require you to notarize a will. All you have to do is have the will has to be in signing. The testator or the person making the will signs at the end. He signs in the presence of two witnesses who are disinterested. He tells them that this is his will, and that the witnesses sign and print their address. The notarization of the will is not required. People ask if the will needs to be registered in the county or what they can do to keep it safe. Some jurisdictions allow you to submit the will to the probate court beforehand, and they hold on to it in their safe. It's not recommended because they will never give you that will back, so if you make changes to it, everyone can see what the progression of your will, how you distributed in the first instance, then the successive wills. The best practice is to keep it in a safe place at home, not in your safe deposit box with a bank, because it becomes very difficult to get into the safe deposit box after someone passes away. Essentially, you would have to go to court and get a court order to allow someone to enter the safe deposit box. It's best to keep it in a safe place with a family member or other individual who you trust, like your executor, whoever you appoint executor. One question that we received is, how do you enforce distribution of the property held outside the United States? So depending on the country where it is held, you have to look to that country's laws regarding distribution of property. Some countries, for instance Canada or some of the European countries, they will allow you to bring a United States will and admit it to court there and have the property that is in the European country or Canada distributed according to the will. Other countries, they do not allow it, so it really depends on each individual country. Some of the countries, Muslim countries, already have automatic distribution according to Islamic law, so in most instances you do not have to do anything, but you have to check each country's laws. Okay, just looking at some of these other questions. Okay, one question is regarding the executor. Can the surviving spouse be the executor, or does it need to be someone who is not an heir? The executor can be anybody. There's some basic considerations that he has to fulfill, like an age requirement. They have to be 18 years or older. They can't have any criminal background. They can't. They must normally be a resident, either a citizen or, in certain instances, it can be a resident alien. But it can be a surviving spouse. It can be anyone who is named in the will. It could be a child, not a child. It could be an adult child. So your son or daughter who's over 18 years old. It could be your brother, but you can have your surviving spouse as your executor or trustee. Okay, there's one question about a revocable trust. Does a revocable trust handle distributing assets before death in ways that are not according to Islamic laws of inheritance? So working around disobedient children. So you should the revocable trust. What you can do with it during your lifetime is essentially whatever you could do with your money. If it's not in the trust, you could do with the revocable trust. But the provisions that you include in it after you pass away should be in accordance with Islamic laws of distribution. The trust, you cannot use it to violate any of the heirs' rights. One question is, how easy is it to set up a revocable living trust? And if you set up a revocable living trust, do you still need to have a will? So if you set up a revocable living trust properly, meaning you transfer all of your assets to the revocable living trust, then you do not need to have a will, but you have to make sure all of your assets are transferred to it. Sometimes people forget to transfer an asset that they forgot about, such as a stock or some other property. Sometimes people don't complete the process of setting up a revocable trust, meaning they don't transfer all of their assets to the revocable trust. And then in those instances, it's important to have a will, or it'll go according to intestate state law. Setting up a trust, it's a little bit more involved than setting up a will, because when you set up a trust, you need to transfer all of the property that you own into the trust's name. So any bank accounts, any real property, houses, rental properties, you need to transfer into the trust. So you have to, it can be a little bit more involved as opposed to the will, where the will takes into effect when you pass away and you don't really have to do anything with it. Okay, and someone had a question about the probate and non-probate estate. So the probate estate, that is a term meaning property that will be passed according to your will. So this means property that you own individually, a house that is only in your name, or your car, or bank accounts that are only in your name. Non-probate estate is referred to property that does not pass according to your will. This is property that passes by operation of law. There's provisions in the law, or when you set up the account, that determines who gets the property. So with a bank account, if you set up a joint bank account with your spouse, the bank account is automatically transferred to your surviving spouse when you pass away. Same thing with a property that is owned by husband and wife jointly. When one spouse passes away, the other spouse gets it automatically. With the IRAs, 401k, pension plans, annuities, if you do not have a beneficiary on these accounts, then it will pass according to your will, but it is highly recommended to have beneficiaries named on these plans. We have one question that says, can a new will make the older will null and void? So yes, when you make a new will, you should include in it that the previous wills are not valid anymore. This will avoid conflicts between wills, and people won't be able to bring the previous will back into existence, or cause confusion. Say that this is the most valid will or most recent will. So you should always include a provision in there saying that the older will is null and void. One question is, if you don't have any family in the United States to become guardian of children, can you make a masjid, or does it have to be a specific person? Yeah, so if you don't have any family in the United States, it's still possible to appoint someone who is a guardian abroad. There's particular provisions that you have to follow, but it's really difficult to do so, and more costly. But you have to appoint a person as guardian of your children. You can't appoint another person as a guardian of your children. So there aren't any more. It doesn't seem like there are any more questions. So we will wrap up now. Just wanted to give everyone a heads up regarding some future. Actually, before we get to that, just some things in the recent law that regarding some charitable deductions that everyone should be aware of. If you take the standard deduction on your tax return, you can take a new above-the-line deduction of up to $300 for cash donations made to charity. These are just provisions that you can talk to your accountant about, just so that you are receiving the maximum benefit when it comes to filing your taxes. So a lot of people use the standard deduction. So this $300 deduction will be very useful for you when you file your taxes next year. So in order to utilize that, be sure to make at least a $300 donation to any charity of your choice. And then also for those individuals who itemize their donations, now they are able to claim a deduction for charitable contributions of up to 100% of their AGI. So again, for those who are itemizing their donations, please speak to your accountants regarding this, so that you can maximize giving to charities. A lot of charities need the money now, and then you can maximize your deduction also. So there aren't any more questions. Let me just double check. So there's one more question. It's asking for family members who will receive a share but live abroad. Should we assign it to someone living here who will in turn pass it to the family member accordingly? So I would recommend if you assign someone to here to receive that share, there's no guarantee that he or she will give that share to the family member living abroad. If you have a lot of family members living abroad, I'd recommend creating a living trust, a revocable trust, because now you don't have to go to court to distribute your estate. It will become when you have family members living abroad, it makes the estate process more complicated. So when you have a will, you have to take it to court. You have to serve process on the heirs. So you have to serve process on the family member living abroad. So he has to sign some documents, send it back. It just makes it a lot more complicated. So I would recommend for people who have family members living abroad that they actually make a trust. It'll make the distribution of their estate easier. Okay, so we're almost coming up on 2 hours. So I wanted to give everyone a heads up about upcoming programs at Dar Islam. One is a Fiqh of Taraweeh program, which will be this Wednesday, April 22nd at 8:15 p.m. Normally we have been having the Fiqh of Fasting workshop every Wednesday with Mufti Minhajuddin Ahmad. This week he will be discussing the Fiqh of Taraweeh. So answering all of your questions regarding praying Taraweeh at home. So a lot of us, unfortunately, we won't be able to attend the masjid at least in the beginning of Ramadan. So we will discuss how you can pray your Taraweeh at home. what things you can do, what things you can't do. Another program really important for everyone is our annual Fiqh of Zakats workshop. This will be Sunday, May 3rd. That's not next Sunday, but the following Sunday at 2 p.m. Again, Mufti Minhajuddin Ahmad will be speaking about the zakat, who you can distribute your zakat to. A lot of people have questions about that. If you could distribute, which family members you can distribute it to, how to calculate your zakat, how to calculate your zakat on 401k, how to, should you deduct your debts, should you deduct your student loan debts, other debts, your mortgages. There's always a question and answer session followed by this. And just as we're talking about zakat, I just want to inform everyone. We do at Dar Islam, we do collect zakat for our students who are studying here, full-time students. You could visit our website for more information regarding that. We have to cover 70 students scholarships this year. So if you are writing your zakat checks now or in the beginning of Ramadan, please consider sending it to Dar Islam for our students who are studying here full time. This Ramadan, inshallah, beginning on the 1st of Ramadan, we will have one daily program at 6:45 with Mufti Azimuddin Ahmad. It's entitled Reviving Your Heart. It'll be a short talk with him, and then zikr and a collective dua. So every day at 6:45, inshallah. And then every night at 9:15 p.m., we're going to be having a tafsir with Mufti Minhajuddin Ahmad, pearls from the Quran. This will be every night. And inshallah, we'll also have some Quran recitation prior to this program. So I hope everyone can tune in and listen, inshallah. Jazakallah khair for listening. If you have any other questions, you can text us at the masjid number, and inshallah we will respond to you. Again, the number is 630-360-2373. And you can also get the slides at our website at majidds.org/lectures.